Sometimes the smallest battles reveal the biggest truths, and sometimes a tech giant's arrogance becomes their most expensive mistake. What started as a simple password dispute would spiral into a legal nightmare that exposed everything wrong with corporate America. One former Apple employee was about to discover that even the world's most valuable company isn't above the law, and that persistence can be more powerful than any billion-dollar legal team. This is the story of how $60 became a $250,000 lesson in humility. It began with the kind of frustration we've all felt, that maddening dance of modern customer service where getting help feels deliberately impossible. I needed my MacBook and iPhone repaired, simple enough. But Apple, in their infinite wisdom, had turned something as basic as scheduling a service appointment into an obstacle course designed to make you give up. After jumping through countless hoops just to book a Genius Bar slot, I was hit with their latest demand: change your password. Again. For probably the 10th time in 2 years. Now, I could still use my Apple ID everywhere else, App Store, iCloud, you name it. But if I wanted my broken devices fixed, password change required. No exceptions. I'd been an Apple retail employee for 2 years before moving on to bigger things, and I knew their customer service principles by heart. This wasn't customer service, this was corporate laziness disguised as security theater. So I did what any reasonable person would do. I escalated through the Better Business Bureau. Apple's response was as cold as their aluminum products, a form letter dismissing my concerns, followed by the phrase that makes every customer's blood boil: Apple considers this matter closed. That's corporate speak for, you don't matter, go away. But here's the thing about telling someone they don't matter: sometimes they decide to prove you wrong. I dove into the fine print of my AppleCare Plus policy, the premium service I was actually paying for on both devices. Nowhere in those pages of legal text was there any mention of arbitrary password requirements blocking legitimate service requests. Apple was essentially holding my devices hostage over a policy that didn't even exist in their own contract. So I filed suit in small claims court for the full replacement value of both devices. Court day arrived, and I walked in wearing my best suit, because when you're taking on Apple, you show respect for the process. The case was called. I stepped up to my podium, and couldn't believe what I saw. Standing at the defendant's table was my former store manager, the same guy I used to work alongside, now wearing a t-shirt and jeans to represent one of the world's largest corporations in court. The judge listened as I explained the situation clearly and concisely. Apple was blocking service appointments with requirements that didn't exist in their own service contracts. I wanted my devices replaced since they wouldn't honor their repair obligations. Then came the moment that changed everything. The judge turned to my former manager and asked a simple question. Are you a lawyer? No, Your Honor. The judge's expression shifted. In our state, only executives, registered agents, or licensed attorneys can represent corporations in court. Apple had sent a store manager in casual clothes to fight a legal battle. But here's where it gets interesting. The manager, perhaps sensing the gravity of his mistake, offered to schedule my Genius Bar appointment right there in the courtroom. The judge found this reasonable and continued the case for 2 weeks to see if Apple would follow through. They did. My devices were repaired, and a senior technician even overrode the password requirement permanently. Problem solved, right? Not quite. I was still out $60 in court filing fees for a lawsuit I never should have needed to file. 2 weeks later, I returned to court, same manager, different judge. This one was all business, slashing through cases with no-nonsense efficiency. I explained that while my devices were fixed, I shouldn't have needed to sue Apple to get basic service, and requested my $60 filing fee. The judge asked the manager the same question. Are you a lawyer? No. Same spiel about legal representation. But this judge, pressed for time, made a decision that would prove costly for Apple. He split the difference, awarding me $30 just to move things along. Except there was one problem: under state law, the prevailing party gets all their court costs. Not half. All. I reached out to Apple's paralegal with a simple proposition: cut me a check for the full $60 you legally owe me, or I'll appeal and you'll end up paying $185. It was an appeal to common sense. Apple's response dripped with corporate arrogance. They would only follow the court's judgment and pay $30. They thought I was bluffing. I wasn't. The appeal went to circuit court, the big leagues. Real judges, real consequences, real law. I arrived in my suit, ready for business. And there he was again, the same manager, still representing Apple without legal training. This judge was different, energetic, wearing a bow tie, clearly enjoying his work. I presented my case about the lower court's error in partial cost awards. State law was crystal clear: prevailing parties get full costs. Then came the question that would seal Apple's fate. Are you a lawyer? The manager had learned something from his previous court appearances. He proudly presented a letter from Apple's chief legal counsel authorizing him to represent the company. The judge's demeanor changed instantly. His pleasant morning energy turned ice cold. Apple does not decide what you can or cannot do in my courtroom. You need an attorney. When the judge asked if I objected to yet another continuance for Apple to get proper representation, I was ready. Yes, I do, Your Honor. They've been told 3 times now that they need a lawyer, and they keep disrespecting this court by sending the same unqualified person to argue on their behalf. The judge turned to the manager with a sarcastic grin and an exaggerated shrug. Sorry. Judgment entered in my favor, $185. But Apple wasn't done making mistakes. 30 days passed. No payment. Their paralegal claimed they were still looking into their options, as if they were going to appeal to the state Supreme Court over $185. That's when Apple made their final error: they forgot I used to work for them. I had my credit union trace one of my old payroll deposits to find Apple's bank, Wachovia. Armed with this information, I returned to court and filed garnishment proceedings. Since I already knew where their money was, I could skip the lengthy discovery process. Within days, Wachovia cut me a check for the full amount, pulled directly from Apple's payroll account. Looking back, this wasn't really about $60 or password policies or even broken devices. This was about something much more fundamental: the moment when corporate arrogance meets immovable law. Apple had every opportunity to do the right thing. They could have waived a nonsensical password requirement. They could have sent proper legal representation. They could have paid a legitimate court judgment. Instead, they chose to fight a battle they couldn't win, against an opponent who understood their weaknesses better than they understood the law. Sometimes David doesn't need a sling to defeat Goliath. Sometimes Goliath defeats itself with its own pride. The real lesson here isn't about lawsuits or court procedures. It's about remembering that behind every corporate logo, every stock price, every press release, there are real people making real decisions. And when those decisions are driven by arrogance rather than wisdom, even the mightiest can fall. In the end, Apple learned an expensive lesson about respect: respect for customers, respect for courts, and respect for the simple truth that nobody, no matter how powerful, is above the law. Sometimes the smallest battles reveal the biggest truths, and sometimes, just sometimes, the little guy wins.